We're going to get started in just a minute. My name is Fiona Schaefer. I'm a partner at Milbank in New York and also the chair-elect of the Antitrust Law Section, and it gives me incredible pleasure to see you all here today. The Antitrust Law Section and this meeting is something that is deeply important to me. I see many friends and colleagues in the audience here, and I'm just thrilled that we're all back in person for a meeting that I think has now already exceeded all records. I'm going to, in just a minute, introduce our wonderful panel here from the DOJ, but first we have, I'm told, a 1-minute video. I'm not sure what it's about, but let's get the video rolling.
Welcome to the ABA Antitrust Section's 71st Annual Spring Meeting. We're as excited as you are.
So excited.
I'm happy to be here.
Hey, this is my first antitrust spring meeting, so I'm very excited.
Every year, we bring you learning, development, and networking opportunities across 3 jam-packed, fun-filled days. The spring meeting is just one of many great section events.
The Fall Forum is great. If you're an antitrust nerd or think you might want to be an antitrust nerd, the Fall Forum is the place to be. So.
The best conference, of course, has to be after spring consumer protection.
I like the brown bag.
Section membership and participation in the section throughout the year is a great way to meet others in the industry.
Just seeing some old friends, people I haven't seen in the last year, so it'll be good to see them. They'll make relationships that last for your entire career.
I love coming to spring meeting and catching up with old friends.
Meet with our friends, especially the friends coming from all over the world.
And to develop and grow as a practitioner through unparalleled professional development opportunities. Enjoy the sessions, and we will see you tonight at the welcome reception.
So without further ado, I'm delighted to introduce our colleagues here from the Antitrust Division for the agency update, all of whom are Deputy Assistant Attorneys General, so I'm not going to say that each time I introduce them, except for Susan, who is even better. She's a Chief Economist at the Department of Justice. So Susan Athey, welcome to our panel here. Manish Kumar to your right, Andy Foreman next to me, veteran from last year. I think you're the only one from last year.
I think that's right.
Hetal Doshi. Next to Hetal is Michael Cadies, and last but definitely not least is Maggie Goodlander. There is not much going on at the DOJ at the moment, right? I can see from the bags under your eyes. You all look great. So Andy, turning first to you. The division's recently notched up some pretty high-profile wins in the merger arena, but you've also seen some losses. And I guess viewing your docket so far, one has the sense that the DOJ is bringing cases where you don't necessarily expect to win. What can you tell us more about how you view litigation risk and what cases to bring? How is your merger litigation programming advancing the frontiers of antitrust enforcement in the merger arena?
Yeah, sure. Thanks, Fiona. It's an honor to be here in front of all of you, and also honored to be on a panel with my colleagues whom I admire so much. And congrats again to you on being the chair-elect. Maybe next year we can produce a cool video like that to start things off. Justice Department. So big question, and I guess I'll start off answering it, and then my colleagues should jump in. You know, look, we were brought in to be aggressive enforcers of the antitrust laws, including in the merger context. We feel like we've done that, and you should all expect we will continue to do that. But when you take a step back in our chairs, you know, there are a lot of, you know, our lodestar is to try to protect competition, right, in the competitive process. There are a lot of ways to do that. One way is to win in court. And so an example of that, obviously, is the Penguin Random House decision. Authors are going to get paid more money. We're all going to have access to a more diverse set of books because of that, litigation win. It also advanced the law in several important respects. It was a labor monopsony case. There were some excellent opinions by the judge on efficiencies. And so that's certainly one way that we could protect competition. I'll get to some of the other decisions in a second. Another way, right, is if we investigate and express our concerns and companies abandon their transactions that we think are problematic, either early in the process or on the cusp of us filing a litigation or even after litigation. And there are examples of those that have happened, I think in the low single digits. And, there are competitive benefits because of that. One example is on the cusp of us filing a lawsuit, the CIMC and Maersk abandoned their transaction, which would have locked up most of the refrigerated containers that are so important to our global supply chain, vegetables, pharmaceuticals, meats that we all depend on, the prices of those are better off today than they would have been because of that, and the resiliency of that supply chain, which we all have seen shocks, recently, has been safeguarded. So that's another way in which we can accomplish objectives. I would also submit that even in some of the losses, while we always want to win, and I maybe take a little bit of umbrage to your part of your question that says we bring cases we don't expect to win. We always want to win cases. We don't always win them, obviously, as folks know, but we always, we don't bring cases that we don't expect to win. But one example of that is the Booz Allen Hamilton decision. That was a unique factual circumstance. Folks don't know. Booz Allen was entered into an agreement to acquire its only competitor for a important national security contract that was going to be let during the review process. So we decided to file suit. And one of the things that the judge, credit to Booz and their lawyers and Everwatch and their lawyers, the judge, found against us. But in the decision, if you read it, she also recognized that us bringing the lawsuit had competitive benefits, because what we were concerned about is that the mere signing of the merger agreement was going to reduce the full-throated competition between the only two bidders. And she specifically recognized that bringing the litigation actually injected some uncertainty in the process, and so the bidding, the people managing the bids, needed to assume that maybe the deal wouldn't go through. They also removed a few interim covenants that caused us concern, including the Booz Allen having approval rights over the bids of the B side. So there are, no doubt we want to win. Not everything has gone our way, but I think there can be competitive benefits in litigation, even if you ultimately don't get the decision that you want. And I think, look, taking a step back to this group works hard every day to follow the facts and apply the law as we see fit. But we were brought in to be aggressive enforcers, and we're going to continue to do that. And again, we want to win every case. We realize that may not happen, and there's the old adage that if you're winning all your cases, maybe you're not bringing enough of them. And so, I guess I'll stop there and see if my colleagues want to add on anything.
So, go ahead, Michael.
I'll just add a couple things. One, I would say every case we bring, we believe is a violation of law, and we have an obligation to bring those cases as enforcers. And the second thing, having now been part of the antitrust community for too long, because it means I'm old, if you only bring cases you are sure of winning, you will under-enforce and you will under-deter. And I think for too long in the agencies, there was a sense, if we lose, the world will come crashing down. And what we need to balance that against is if we don't bring cases, we are saying that conduct is okay. And that cost is very large, and I think we just are as Andy said, that's what I think being an aggressive enforcer is, understanding that your decisions not to enforce can have as dramatic of impact or a greater impact than bringing cases that may be tough on the law or the facts, and that you might lose.
All very well said. Maggie, as part of your broad remit at the Department of Justice, one of the areas that you oversee is the appellate program, including for cases that you've lost at first instance, such as United Sugar, which is currently in progress on an appeal, and others where you file an appeal, but I think you've recently withdrawn, such as United Change. What can you tell us about the appellate program, what cases you choose to appeal, and also more broadly, the amicus program, which I think was a great development that we saw started in the last administration, but you've continued.
Well, thank you so much, Fiona, for having us here. This is my first ABA spring meeting, and after that video, I will definitely be back again and here in the fall. But it's a privilege to have the chance to work with this group of people every day. Most days I feel like I should be paying some sort of tuition to the U.S. government for the job I get to do, and it's really nice to be in a well-lit room with all of you. So I guess I'd just start with what is, I think, a shocking but perhaps unsurprising set of contextual points. The first, and it's actually, I'll just take you back in time, 45 years ago, to the year 1978. 1978 was the last time, March 1st, 1978 was actually the day when the United States last appeared before the United States Supreme Court as a petitioner in an antitrust case that arose from a DOJ enforcement action. So it was 45 years ago. Jonathan Cantor had just turned 5 years old. And Merrick Garland had just started a year-long clerkship with Justice Brennan. So just to put it into context, the last time the United States appeared as the respondent before the Supreme Court in an antitrust case that arose from a DOJ enforcement action was 1985. And the last time that the Antitrust Division pursued a merits case in a court of appeals was almost a half decade ago. So this is all to say, a question that I've thought about a lot since starting in the division is what is exceptional about antitrust appellate cases? And I think, one thing, well, they're exceptionally awesome and very interesting. The stakes are really often very high. They're rare, but at bottom, I think what I've come to see clearly is they're very much like any other case in a sense. We have statutes, that we read and we interpret, and we have case law that we seek to apply. And so as much as we find the cases interesting and they're exceptional, at bottom they're very similar to, and Hetal and I both come from outside of the antitrust world. And so I think this has been a really interesting part about getting acquainted with our amazing appellate program. On the amicus program, what I'd say is, yes, we've really continued this great tradition, which is a pretty recent one, of weighing in on amicus briefs. And as someone who, as a law clerk, worked for 2 judges who were avid readers of amicus briefs, I can tell you that from an Article 3 perspective, I think these are often very useful. From where I sit now, the greatest gift that anyone can give us is an amicus brief in support of a case, in a merits case. So if you're thinking about Christmas gifts, that's something to keep in mind. But we also have, we've tried to build out the amicus program and to address ourselves to what I think, just to come back to the point at the outset, which has been the absence of appeals and the absence of the United States in the courts of appeals, articulating our view of the law. So we have a program, as with almost all the exciting things that happen in the Antitrust Division. Jonathan Cantor has given a code name to this particular initiative. We call it RTAF, Real-Time Antitrust Filings, and it's a really exciting operation that has involved not just our appellate section, but attorneys from across the Antitrust Division.
And I can tell you from personal experience, having just been to England and visiting some universities there, your amicus briefs are read beyond the United States as well. There is great interest in the program itself as a process as well as the substance of what you're articulating in these amicus briefs. So anyone wanting an amicus brief in their case, Maggie is here to listen. Heschel, the DOJ's merger cases and policy statements, I think we all agree, express a much more aggressive enforcement agenda. Do you ever get concerned about potential over-enforcement and the possibility of chilling pro-competitive, innovative deals, or do you feel that the United States is at this point just overly concentrated and we need to discourage further consolidation?
Thanks so much, Fiona. It's good to see all of you and to be back. I've learned my lesson from last year, those of you that are here, so I'm not going to introduce myself in reference to any hip-hop lyrics. So it's good to see all of you. Thank you again, Fiona, and congratulations on your appointment for the upcoming year. It's a pleasure to work with you on this panel. So this is an interesting question because, as Maggie noted, she and I both come from outside of the deep expertise that our colleagues like Michael Kadish and Andy Foreman, Manish Kumar, and Susan Athey bring with respect to antitrust. And part of that means that we have, or I think that I've had the benefit in working in other areas of the law of taking a little bit of the macro or broader view. And so this refrain of the tension in terms of how to calibrate innovation and progress in our business communities and in our markets against the perils that can befall consolidation or in other areas of law like the white-collar prosecution realm, right? Potential frauds and mischief of that sort. Calibrating that risk is always an issue, right? And what I often come back to as the guiding principle in terms of thinking about how to calibrate that risk is that that's actually not my job. Congress has stepped in there and said that this is the law and this is what I'm required to do in terms of enforcing that law. And so I often think, it's an incredible time to be in the antitrust space. It's in the zeitgeist. It permeates every aspect of our life. It's so exciting to be part of a world where anyone you talk to on the street, when you lawyer or not, and you say you do antitrust work, they have a lot of thoughts and feelings about the state of consolidation in America today and a lot of different industries. But what I continue to come back to is this idea that it's not so much aggressive enforcement, it's just enforcement. And so bearing that in mind, I have an enormous degree of confidence that the adversarial process, both in the courtroom, but also the investigatory process, which I view as not adversarial necessarily, is the check in many ways in terms of making sure that over-enforcement isn't chilling that type of innovation. I think what we're actually seeing is that the fear of that, to my colleague Kadish's point just now, is that the fear of erring on the wrong side of that line has led to under-enforcement in the sense of saying, well, if we're going to err on one side or the other, it's better to err on the side of caution. And I'm not sure that that's served us well as a society and as just as financial markets and writ large in terms of where we've ended up. So I suppose the answer, Fiona, is that I have an enormous degree of confidence in this bar in terms of the lawyers that appear with us and against us in court in terms of making the right arguments such that the calibration is finely tuned to avoid those perils. But this is just enforcement. I don't think it's anything other than that.
Well, I'm happy to hear that the investigative process is not adversarial and that you view us as partners, because that's the way I've always seen it, and I think we can collaborate to get to the right results in these cases.
I can't say that everyone in this room feels that way, but I feel that way.
I wanted to turn to Manish and firstly congratulate you on your newish gig. We're delighted that you're in position, and we're looking forward to you bringing many more cases under the revamped leniency program. One area of enforcement that has continued through this administration and is really heightened, I think, in this administration is the whole focus on labor markets, wage fixing, no-poach cases. And some would say maybe to the, not exclusion, but certainly a priority maybe over traditional price fixing, bid rigging cases and output markets. Why are these cases continuing to be such a priority for the division, and do you expect that to continue?
Yeah, thank you very much, Fiona, and thanks so much for moderating our conversation today. Let me first start out by saying just what an honor and privilege it is to be speaking among the very distinguished and talented members of this panel who have really enjoyed working with over the past couple of weeks and who I already have great affection for, except for Michael Kadies. It's a joke.
He's just saying what the rest of them are thinking.
I also just want to communicate the fact that I'm very honored to be speaking among everyone who's assembled in this room. I have grown up in this antitrust bar, and I have been mentored and supported and worked with many folks that are assembled here. I'm looking directly in my line of sight is Marvin Price, who, for example, has provided me with so much advice and so many conversations over the years. So it is very much an honor to be speaking to all of you. And I want to say that since I am the product of this bar, I'm an object lesson in the perils of mentorship. So I'll turn to actually answering your question, Fiona. And in order to do that, I guess I'll just try to provide two recent examples of cases that have been brought by the United States in the labor market space that you were referencing. The first one is a case that was concluded last week. As many of you probably know, that case resulted in acquittal for the defendants. It was a case in the District of Maine alleging a no-poach conspiracy. The victims in that case were frontline workers providing healthcare services during the pandemic. So that's one recent case. Another case, Fiona, was one that was concluded in October that resulted in a guilty plea as well as a fine and restitution to the victims of that conduct, who were school nurses providing services to a public school serving medically fragile students in the District of Nevada. So these are two cases that resulted in very different outcomes. But from the perspective of the DOJ, we think these are both highly worthy cases, and we look at them in the same way. They're about cases that are protecting the economic liberty of individuals to sell their own labor into a competitive market and therefore to earn a livelihood. So we think these cases are very important. They ultimately are about allowing individuals to pursue the American dream. And in terms of whether or not these cases will continue, we all signed up to be prosecutors, to do the right thing for the right reasons and in the right way. And we very much think that these cases are worthy, and so we're going to continue to bring them.
One observation I have, having just come from a trip in South Carolina and Tennessee with my sons, I was picking one of them up from rowing camp. I'd never really been to that area, but I view it as maybe part of the heartland of the US, and I thought I'd do a little vox populi to see what do people know about the Department of Justice's and the FTC's focus on labor markets and protecting workers. And I found that A, there wasn't much knowledge, B, there was misinformation in the sense that people thought, well, that's just going to raise, labor costs, and we've already got supply chain issues and everything's too expensive. So it made me think, do you need to do more of an education campaign, both with judges and the general public, to help them better understand what your goal is here, that it is indeed, as you've just said, protecting mobility and economic freedom of workers?
I think community engagement is a very important part of our practice at the Antitrust Division. And so we've certainly had conversations about the need not only to communicate the importance of our labor market enforcement program, Fiona, but antitrust principles in general. We have focused I think Jonathan Cantor has spoken very eloquently about the importance of, kind of this access to justice initiative that we have at the Antitrust Division to ensure that our policy statements and our enforcement actions are understandable by the layperson. So I definitely think there's a place for that. So onto a topic that is near and dear to my heart, Susan.
we've got big tech cases, Amazon, Meta, Apple, Google. I think everyone knows about those. They've been an obvious area of focus for the antitrust agencies. But technologies like machine learning, AI, and algorithms are starting to get a lot of attention as well. And just to digress a little bit again, because that's what I do. About 2 months ago, I got a call at 2 in the morning. It was an unusual call. It was my son from boarding school. First of all, he never calls me, much less at 2 in the morning. He called and he said, "Mum, I'm terrified." I said, "Of what?" He said, "Have you heard of this new thing, ChatGPT? It's terrifying." I said, "Really?" He said, "It's also incredible, and I've been up all night like playing with it." And of course, then I had to get on and see what this was all about, which of course took me several days as an old person. But that's a long way of saying that these kinds of developments, I think, are life-changing in antitrust and for all of us. So what are the implications that you see in antitrust enforcement with developments like ChatGPT? What emerging issues are you paying attention to?
Yes, thank you so much for having me here, and it's a real honor to speak to this distinguished group. So as someone who's been working in AI and machine learning for a long time, you often see that things can be a little more hyped than they really are. But I think the last year, the developments that have come out even surprised an insider like me. And so I think you put it well. There are these amazing opportunities, across so many dimensions of our society to get people better services and to meet people's needs in a more precise way. But of course, there are enormous risks, and when things move so fast, there's anticipated and unanticipated risks. I think when I first started working at the intersection of machine learning and AI and antitrust, one challenge was that no one knew at all what I was talking about. So I went all around the world, and I would have to start from square one. People just had no idea what was happening behind the scenes of all these services. And I think one really profound observation today is that enforcers around the world have educated themselves, and they are much more sophisticated, and they do have a better idea and are, I think, more forward-looking. People have learned from the past. At the same time, things are changing so fast that no one knows. Even the people building the technology don't necessarily understand all of the opportunities and risks. And I've been working very closely with people building it in my academic life. So it's really true that, that people aren't really understanding exactly how it all works. So there's a few things to keep your eye on, both inside and outside of antitrust. One thing is just making sure we understand the issues around the data. What's the data going in? Where is it coming from? How is it being protected? And then we're all using it, and people are putting a lot of information in that's much more revealing of your interests and needs than even what you might have put into a search engine. And so it's also going to be very important to make sure that both the consumers and businesses understand what's happening to their data as they use these services, both the core services and the layers on top of it. So those are a few things. From an antitrust perspective, what we've seen over the past decades is that technology shifts can create opportunities for changes in leadership, for disruption, for new types of entry. And faced with that, incumbents can sometimes find it easier or take a shortcut and to engage in anti-competitive conduct to maintain their position when threatened in this way. And so I think we've seen that playbook happen before, and I think everyone's going to be watching carefully to make sure that in the face of these tech shifts that firms are competing on the merits rather than engaging in anti-competitive conduct.
I'll come back to the specifics in a few minutes on the withdrawal of the information exchange guidelines, which I think is very significant. But before doing so, Heschel, I wanted to talk to you about some other big tech cases, the Google cases, obviously, there are reports of investigations of Amazon, Apple, Live Nation, and Visa. Is the curse of bigness really true in the United States? Is Tim Wu right? And I wonder if we were looking at these kinds of big tech developments and they were promulgated by, say, Chinese companies, would we be looking to defeat them, or would we be like making them national champions, global champions? What's your thoughts?
So the disclaimer first is, I'm not going to comment on any pending investigations or any pending litigations, but what I will share is that this is much like the earlier question that I answered, very much something that's on the mind and in the hearts of a lot of people that work in this space. And I want to start with this idea that I come to this from a background in tech, a deep interest in tech. As some of you may know, I did a lot of work with respect to digital assets and cryptocurrency before taking on this role. And so I have just...
That was a good move, moving from cryptocurrency.
No comment. But what I will say about that is that I come at this from a perspective of a deep and a profound appreciation for the way that technology has fundamentally shaped our global economy in ways that really advances democracy and a lot of access to justice, all of these things that are very much wrapped into the priorities of this particular administration and this group of people. And so to answer your question, Fiona, no, it's not that big is bad. It's that there has been two different things happening in tandem that has led us to this cultural and economic moment where we've ended up today. The first is, there was a long time, where before big tech was big tech, it was just tech. And we didn't know as a society how to think about the fundamental business models that we've been accustomed to shifting in terms of the existing paradigm of law. And then in addition to that, there was and continues to be the fact that the judiciary and litigation is often the least quick, the least expeditious way to accomplish certain types of, it's meant by design to be the slowest, right? Inertia is built into the system. And so we've landed at a place where for some period of time, for reasons good, bad, and indifferent, we haven't seen a lot of enforcement in that space. But as I said earlier, we look around and it's clear there are problems with respect to how we approach technology and consumers experience and interact with technology in our society. And so I think that the prism through which I think about big tech matters, whether matters we're litigating or thinking about litigating, is always the fundamental principle of harm. And so if you're thinking about where to allocate our time and resources and the true impacts of monopoly as it affects Americans, that prism of harm is what is our guiding principle, not the bigness of the industry.
Yeah, I think that's a really helpful setup also for my question to you, Michael, which is going back to the information exchange, policy withdrawal, and indeed the withdrawal of a number of guidelines, including in the merger remedies arena. So Hetal has, I think, very eloquently described the new world we're in. We're in a very dynamic, tech-driven world. It's very different from the world in which many of these guidelines were developed. But untethered from guidelines, it's kind of difficult to give good advice to clients, and it's probably even more difficult for courts to understand where they should come out in these complicated cases. Do you think the absence of guidelines is going to hamper your efforts in the courts?
Absolutely not. Look, guidelines, we enforce the law, right? Oh, before I go, I just want to say I really enjoy everybody on this panel except Manish. But no, it's an honor to be here, and it's honestly it's such an honor to be part of the administration in this role. I've had a series of jobs, and I have to say, in 10 months here, I continue to have those same butterflies in my stomach every day I come to work. And the best thing about it is both the colleagues here, but also just the incredible talented and dedicated civil servants within the division who often go unrecognized and who are really responsible for 99% of the success we have and far less of any of the lack of success we have, which probably falls on Manish, even on the
It's definitely true.
But Right, I mean, the guidelines don't, when we issue guidelines, they don't change the law. When we withdraw them, we don't, that doesn't change the law either. And in terms of particularly the healthcare guidelines, actually just said before I get to the healthcare guidelines, right? Like, and I guess I'm enough of, maybe it's just, Heddle beats it into me, but I think I even had some of this beforehand. At the end of the day, when we bring enforcement actions, we win cases where we have a solid legal theory and we convince the courts about the way competition works in a market, how the challenged conduct or merger is likely or did change that, and how it harms the process. And our job is to do that. Your job is to counsel your clients in that way. And the problems with guidelines that don't ever change or that are set 30, 40 years ago is the world changes, the market changes. I mean, when we think about, I don't use ChatGPT because I'm figuring this is the innovation that destroys my profession. But hopefully I can get to, retirement. But I mean, think about information sharing, right? The phones in our pocket are more powerful than the supercomputers in 1993 when we issued the healthcare guidelines on information sharing. Right? We have, right, when we think about machine learning, right, I was just reading the other night, data with the machine learning today, you can take a computer program, give it 4,000 images, 4,000, that's not a lot, and it becomes 99.5% accurate in diagnosing a problem. So when we look at the safe harbors, to think that those safe harbors, which were not explicitly tied to the law, that they would still make sense in this world where it is very easy to leverage data and computing power and artificial intelligence and machine learning, it's sort of bizarre that we actually left that around for so long. And yeah, things are changing, and that makes everybody's job more difficult. But what we should be concerned about is when is safe for information? When is it going to be anti-competitive and harm things, not whether it fits into a safe harbor.
So I think we all agree the world's changed radically since 1993 when these guidelines were issued, and we're not expecting apparently any new guidelines anytime soon on information exchange. But I think many of us are just grappling with, well, what is safe in information exchange land in a world without safe harbors? And I know that the answer lies in the law, but last time I checked, that the law hasn't even gotten to ChatGPT. One request to you to think about is, could we do some kind of workshop? If we're not going to do guidelines, could we actually get together and at least collectively understand what the power of AI is in connection with information exchange? Because I personally don't know how much aggregated data can be disaggregated. How could it be identified with specific competitors? I mean, this is apparently happening out there, and it sounds like you're seeing it in your investigations, but I think our legal community could really benefit from an education on the power of these tools and what can be safe in the current environment.
So I guess I'll take that under advisement. I don't really have that authority, right? But is it right? I mean, it just seems to me that the question we think about in any case, the question you should be thinking about, what data are you sharing? How is it being used? And what is the impact? Okay, and if the impact seems to be it's suppressing price competition, it is eliminating certain forms of competition, yeah, that should send red sirens off. And right, I mean, there is, I think, in this administration, a concern right, with safe harbors, because safe harbors, we can't change the law, and yet a safe harbor, in some sense, is us telling the courts that we think something isn't problematic. That's not our job, and the dangers of blessing conduct that turns out to be problematic is costly. I mean, look, none of us are in antitrust law because it's easy or simple. And our job is hard, and your job is hard. And yes, of course, it's a lot easier to counsel people if we give you very bright lines, but the last time I checked, you all don't like when we have bright line per se rules against things. Well, it's unsurprising that enforcers often have concerns about bright lines about what is when things are per se legal.
Fair point, and I really look forward to our workshop. Speaking of technology and information exchange, what about third-party messaging platforms, Manish? We've seen the memo from the Deputy Attorney General referring to the compliance risks posed by third-party messaging platforms. We've also seen huge fines levied in related areas by the SEC for non-compliance in connection with third-party messaging platforms. What should we understand about the use of this technology in your investigations?
Yeah, so Fiona, we're definitely observing the increased use of messaging platforms with this type of functionality. From the perspective of an enforcer, it's something that causes us to have a considerable amount of concern because of the implications that the use of these technologies have for the subjects of our investigations to appropriately preserve and produce responsive communications and documents. So I would hope that recipients of investigative process from the DOJ and other agencies really would be taking the appropriate steps to turn off functionality in messaging platforms that introduces kind of an ephemeral messaging capability, so they could ensure that they're appropriately able to respond to an investigative process. And in addition, I think it's important for this audience to note that the DOJ and the FTC are working together in order to take appropriate steps to ensure that the integrity of our investigations is not harmed by the use of this technology. So the DOJ and FTC have formed a working group in order to ensure and consider revisions to our investigative process. And I'm talking here about language that you might see in grand jury subpoenas, but also document schedules occurring in civil investigative demands or second requests to ensure that these types of communications and documents are appropriately captured.
And just, I guess, to put a fine point on it, would it be your position that even if a company has a policy that says employees are not permitted to conduct any business on social media, that you would still expect such social media communications to be preserved in a criminal or civil investigation, assuming there was business communications on them?
Yeah, I mean, it obviously really depends on kind of the facts of what the company knows and the extent to which, and the manner in which individuals are transacting in business on these messaging platforms. But there's definitely a situation where we would expect that companies are taking appropriate steps, for example, to turn off that functionality or not make it permissible on company provided equipment in order to ensure that they can comply with the investigative process.
Well, we'll certainly be interested to see how this develops. I feel like WhatsApp is the new email. You used to get excited about email, now that's boring. Let's go straight to the WhatsApps of the world.
Yeah, and that's, as I said at the outset, I think that's definitely something that we're observing in our investigation, so we're trying to take appropriate steps.
So Maggie and Susan, I was a little disappointed that the merger guidelines weren't quite ready for this spring meeting. I would love to have your commitment that they'll be ready before next spring meeting. Hopefully you can give that. What can you tell us about the DOJ's priorities and perspectives in approaching the revision of the merger guidelines, Maggie?
Sure. Well, thanks, Fiona. You've heard a bit about our perspective. I think there are two kind of threshold questions that have really guided our work in this area. One is, what is the purpose of the guidelines, and who are the audiences of the guidelines? And I think actually the relatively short history of the guidelines have been instructive. The first set of merger guidelines from 1968 were issued by Assistant Attorney General Don Turner. He was assisted by a then young lawyer, Stephen Breyer, in drafting the 1968 guidelines, which made clear, to the point that Cadis was making, that these guidelines reflected the current views of the Justice Department, that they were subject to change without notice, that these were not, this was not an effort of lawmaking on the part of the Department of Justice. It really, much like the federal principles of prosecution, which were issued about a decade later, 12 years later in 1980, by Attorney General Ben Civiletti, then assisted by young attorney Merrick Garland, in writing these federal principles of prosecution. The idea, I think the animating idea behind guidelines within the Justice Department, and Heddle should speak more to this as well, as someone who lived and breathed the federal principles of prosecution every day. But the idea is we recognize, as Justice Robert Jackson said, that the prosecutorial power is, he called it one of the greatest peacetime forces in our country. We understand the enormous power that we wield and the importance of exercising that power and that discretion in a principled way so that we are treating like cases alike and we are adhering to the basic principles of the rule of law. And that, I think, at bottom is what the guidelines are about. And so an essential audience for the guidelines are enforcers themselves. In addition, so to your point earlier, Fiona, about courts, I think what we've heard over many years is that courts may look to the guidelines, but ultimately they're going to look to the same sources that we look to. They're going to read the text of the statutes that Congress wrote. They're going to read the decisions, particularly decisions of the Supreme Court and relevant circuit precedent that interpret these statutes. And they're going to read our briefs and they're going to read your briefs, and they're going to come to a decision in a particular case. And so I think a recognition of what the guidelines, what role they serve, what their purpose is, and who their audiences are, has been a really important set of questions. To your question about priorities, I think there are kind of 3 points to make. The first is the point that's been made by my colleagues, which is, really at bottom our mission is to ensure adherence to the law. So I don't think anyone will be surprised by anything they see in the guidelines if you've read 15 U.S.C. 18 and the relevant cases that interpret the statute. One of the threads in the Supreme Court case law that we pay close attention to is the basic principle that we are obligated to pay very close attention to undertake a careful analysis of market realities. And that is really a principle that's at the core of our thinking, and you see it in our briefs that we file, you see it in all of our court filings, and you'll see that basic principle in the guidelines as well, reaffirmed most recently by a unanimous Supreme Court in the Alston case. So in addition to market realities, we've part of this process has been to really pay attention to the relevant market participants and to listen to the relevant constituencies. And for us, the ultimate client is the American people, workers, small businesses, farmers, and consumers. And we've done a lot of listening, we've done a lot of learning from many of you as well. And it's been, I think, an open and a really productive process for us that was much needed. The final thing, relatedly, and this kind of goes to what Manish identified as our Access to Justice initiative. A big piece of what Assistant Attorney General Cantor, I think, part of what's been really inspiring about being part of this team is his commitment to democratizing the enforcement of antitrust law. And part of that is the input that we receive through, actually as part of the guidelines process. But we've also done, I think, a lot of work and paid close attention to trying to open up channels of reporting. We have, in a variety of contexts, including in the agricultural context, which I hope you'll talk about, Cadis, we have a citizen complaint portal. We're working to develop that and to build that out because I think we're finding that we learn so much from impacted communities, including those that maybe haven't had as loud a voice or as assured a seat at the table. So I think my message is there's no need to be afraid as long as you've read the statutes and the cases and read our briefs and we'll read yours, and I think we'll all be okay.
That's very reassuring. We look forward to reading them. Susan, on that note, can we expect that we're still going to have some of the classics, the presumptions, HHIs? Surely as an economist, you like Herfindahl's. What are your economic priorities in the guidelines, particularly bearing in mind comments from AAG Cantor that modern transactions don't neatly fit into vertical and horizontal categories, and that you've been looking at mergers in a multi-dimensional way?
Yes, well, first of all, there's very well-established concepts and principles here that have served us well, and so I don't think we need to worry about big surprises there. The real priorities for me are thinking about how the high-level frameworks that we have about the effects of mergers on competition, how those are being applied in a more modern and complex economy, as you say. In the modern economy, we have a lot of firms are selling multiple products, products that are different versions of the same product, but also products that serve different needs but are related in other ways. One product that affects how people make choices about other products, and so on. So the relationships between products and the relationships between firms they've always been somewhat complex, but it's just much more common to see these complex interactions. We also have mergers where the motivations might involve data, mergers between platforms, mergers where there might be potential harm for competition in input markets or in labor markets. And again, from an economist's perspective, the efficient allocation of resources is important in all parts of the economy. If we suppress the wages of nurses, well, that affects people's incentives to go to nursing school. That leads to nursing shortages. That means people don't move to the towns that are facing those shortages if we're suppressing wages. So, we need to think about how competition works in all the parts of our economy if we want to have good outcomes. So when we're thinking about more complex mergers, we want to start with the question of just how does competition present itself here? We really want to understand the nature of competition based on the facts, based on first principles. And a priority for me is just to make sure that we don't lose track of things and get confused in applying the basic logic of competition to these more complex circumstances. So really making sure that the guidelines are understandable, that the logic is clear, that they're transparent, even in a more complex world.
Is it fair to say that you'll be building on what's already there, or should we expect to see something completely different?
As I said, I think the principles here are well established in terms of what our goals are, and so I think of there being an elaboration of how those apply to a wider set of fact patterns.
So in another policy shift, Andy, we've seen the government, the Antitrust Division, pronounce that you're no longer in the consent decree business when it comes to mergers, and you've withdrawn the merger remedies manual. You've also indicated that if parties want to fix it first, as it's called, that needs to be done, it seems, in specific ways. And I know you can't comment on pending litigation like the Assa Abloy case, but it seems that the DOJ's position is that a fix-it-first remedy may need to be applied before presenting the transaction in the HSR process. What can you tell us about your approach to remedies generally, policies, and how we can, comply? Because we want to comply.
Sure. So, again, I might quibble with we're no longer in the consent decree business. I think what we've said is it's an extremely high bar for us to take a merger remedy. I think we've seen many examples. There's literature on this. We've had examples that we've all lived. I'm coming up on a year at the division, and I think the first week on the job, there was a consent decree that crumbled. So I think there are several examples when divestitures, particularly carve-out divestitures, have failed. And I think it's important to realize that when a divestiture fails, the American people bear that risk. And the competitive problem that we originally were worried about really cements itself. And so, and of course, as everybody here knows, whenever there is a consent decree, we need to make a filing under the Tunney Act that says we believe, as the Department of Justice, that the remedy is in the public interest. And so it's going to be a high bar for us, given our views on the fact that there can be real risks associated with divestitures. In terms of the fix it first, we're trying to come up with a catchy alternative to that because we don't really like that name. Maybe at that work we'll design a workshop for that or something.
I would love that. I love that.
I want to. We are. I think in about 10 minutes. Well, 2 minutes. There's a court hearing that's going to start down the street. So I want to be mindful of that. These are issues that are in active litigation. And our brief is public, so folks should read that. I think what I would say is overall, in terms of the brief, if a remedy is presented sort of before or during litigation as a part of to cure the underlying violation that we believe is let's say during the litigation is the fact scenario that we investigated, we brought suit on, a divestiture is put forth in that litigation outside of the HSR context. We think it should be treated as a remedy, and there's a long history of remedy law that we think should be applied. So if it looks like a duck, quacks like a duck, it should be treated like a duck in terms of the being treated as a remedy. And I think that's really where our views are. Obviously, there's a lot of nuance in the brief. I won't go into it here, but I think that's our general perspective on it. Last thing I want to say, sort of proactively, because we've seen this. There's been a narrative over the last couple of months. This goes back to the consent decree policy. That there is some kind of shadow consent decree approval process where we're engaging and we're actually doing consent decrees, but we're not announcing them. And I can just say that's categorically false. It's not happening. We don't really know where this is coming from. There may be an instance or two where we decide in our discretion to monitor instead of bringing enforcement action, but the notion that there's this sort of shadow way to get a consent decree is just, it's not happening.
Good to have that clarification. And I'm curious, what do you not like about the term fix it first? Because that may help us understand how we can better fix it first.
We'll litigate the fix. Well, it sort of assumes that it fixes the problem. So that's one of the issues.
So attempted fix it first could be.
Yeah, Hedl, did you want to add anything?
No, I mean, in light of the hearing that's about to start, our brief lays out exactly our position. Actually, one thing I will say, I think Andy laid it out perfectly, is in thinking about divestitures and sort of the road to where we've ended up today, I think that the point that animates our briefing there and just the policy writ large is that despite the best of intentions, the idea that a divestiture is going to cure the underlying violation, like the risk to the American people can't be based on our hopes and aspirations of what we hope will happen. right? And so the way that we're thinking about the remedy posture, particularly when we're in litigation, really it inheres in our obligation to make sure that we've fully teased out those risks and that the court is aware of those risks as opposed to aspirational goals. I think that's the framing that we're thinking about this through.
Can I just add one point
Yes.
on a tribute to the Tunney Act? The Tunney Act is one of the great post-Watergate statutes, and this administration came in with a deep and clear commitment to restoring the basic norms of the Justice Department, and so much of that work was done post-Watergate. So to Andy's point, that this notion that there are shadow settlement agreements or shadow agreements that somehow would come outside of the scope of the Tunney Act is really just inconsistent with our fundamental values and commitment to, and I would just say as a person who comes to antitrust law from administrative law and constitutional law, the Tunney Act is just such an extraordinary statute. It's one that brings the public and the courts and the Justice Department together and requires reasoned decision-making and transparency, and we honor the Tunney Act.
So I feel compelled.
Go ahead.
And I think the other thing I just wanted to add is what drives our views on consent decrees comes from the statute itself. Right? The statute says a merger is not legal if it may substantially lessen competition. Not that it will.
Or tend to create a monopoly.
Or tend to create a monopoly. May means may. So if we're faced with a situation that someone says, don't worry about the merger because there's this remedy that we're going to do, the bar for that remedy is quite high because it has to eliminate the possibility. It's not just whether it's more likely or not. And so, I think we forget that the Clayton Act's words are actually, it reflects a congressional intent to really put a thumb on the scale of protecting competition.
I guess just to go back to the Tunney Act point, we love the Tunney Act too. We wish we could be using it a little bit more right now. And some might argue, I'm not saying I'm one of them, but that not having consent decrees kind of takes us back to a pre-Tunney Act world where, the parties are doing their own thing. And is that, from a policy perspective, better than what may be an imperfect remedy in a consent decree process that's monitored?
Look, I'd just say, I think to Andy's point, the Tunney Act hasn't gone unused in this administration, and the standard is an exacting one. It requires a settlement that is in the public interest and one that the public has every right and we have every obligation to listen to feedback on. And so it's a demanding statutory procedural framework and substantive standard, just as the underlying Clayton Act standard is itself one that lends itself to the protection of competition.
I did want to spend a few minutes on your whole of government approach, which I think has been another notable trend in this administration. President Biden himself issued a very broad-ranging executive order. If you haven't read it, you should. It's really a call to all government agencies that have any kind of competition mandate to use it and not, frankly, be asleep at the switch. That was a Freudian slip. My son just discovered that we were apparently related to a witch in Salem. So I said...
Did he learn that from ChatGPT?
No, he learned it from Ancestry.com, which he is now barred from getting into. So in any event, what can the panel tell us about your engagement on the whole of government approach? Who are you engaging with? How receptive are they? I know that, the USDA with the Packers and Stockyards Act has been an interesting initiative. The DOT with JetBlue and Spirit, of course, the Department of Defense with the Everwatch BAH case, and the FCC and with the Standard General Tegna transaction. Tell us about how you're collaborating and how that makes you more effective as enforcers. Michael, start with you.
Or
Maggie?
You go ahead.
Maggie's a better speaker than I am, so I kind of like to let her go first. Look, this is a very important priority for this administration. And, I think when I was talking to Jonathan before I took the job, he was like, if you look through the U.S. Code, the Sherman Act, the Clayton Act, even the Federal Trade Commission Act are not the only competition statutes. And Congress, even when it regulated, often gives those regulators competition, as you said, mandates. And then somehow those mandates have kind of gone, for a variety of reasons, sort of fallen by the wayside. And, that puts a lot of responsibility on the Sherman Act, and is not consistent, again, with the statutory structure that Congress has created. And so part of what we're doing is we reach out to agencies, the FCC, who traditionally, there's been a relationship, USDA, and DOT, and part of it is talking about making sure they understanding what problems they're seeing and thinking about the best ways to address them. I think maybe the most obvious example here is the Packers and Stockyards Act, right? Which, if you sort of just a brief history, Fiona brought it up, so you're like, look.
Give us all 100 years, please.
May I commend an article by Mr. Kadis on this very subject?
Yeah, your check's in the mail. Right, but if you go back and look, right, the Clayton Act was passed because Congress thought the Sherman Act wasn't working, and they passed the Federal Trade Commission Act. The first thing the Federal Trade Commission does is it writes a 3-volume report about the failure of competition in the meat packer industry, despite an area where there had been a lot of enforcement by the U.S. government. And so then they passed in 1921, which I would say is not the most progressive liberal era of American history, the statute, which if you look at the key operative section, it's like someone sat down and read every case that was bad for enforcement and wrote the statute to basically overturn that. And until last year, this is the first time that the division has brought a Packers and Stockyards Act case. And in the interim, we went from a meatpacking industry that was deconcentrated to one that's heavily concentrated. And part of that, just as an example, is it's about us, the way to reinvigorate that involves both working with USDA to figure out how to best enforce the act. And I think hopefully that serves as a model. And it's really at some level, when I think about the competition executive order, it's really like, guys, we're one government and we shouldn't be siloed. And when we're siloed, we're exploited against each other. So I think, that I would say, I don't want to talk about, obviously, the litigation with JetBlue, but, Congress gave the Department of Transportation the requirement to make a public interest determination anytime there's a merger. They need to do that. And, kudos to Secretary Buttigieg for saying, hey, we're going to do our job.
I personally, as a consumer and even as an antitrust professional, find it pretty exciting that you're all going back to the statutes, some of which have been overlooked for many years, like Section 8, the Robinson-Patman Act even. I mean, I'm not sure my clients are so enthusiastic about this look at history, but what else is out there that you're thinking about that's laid dormant, whether it be an antitrust theory, particular line of cases, or statutes that could be revived and we should know about?
I'm really glad that you recommended everyone read the executive order, because I'm glad I didn't have to do that. It is a really great read, and where it starts is, the whole of government approach sounds, maybe it sounds some sort of glamorous to some people. It did to me. The work itself of a whole of government approach really involves a lot of time in really neglected corners of the U.S. Code. So we have Title VII, the Packers and Stockyards Act. We have Title 12, where our colleagues at the CFPB and our bank regulators have antitrust authorities. We have Title 49, where the Department of Transportation and the Surface Transportation Board are looking at their authorities and using some of them for the first time. We have our partners at the Federal Maritime Commission and our partnership there. So what I'd say is that the executive order has led us to dust off the statutes, which, you know, it's probably a good thing that a federal law can really only die in two very clear ways. One, if it's repealed, or two, if the Supreme Court strikes it down. So all these authorities are there and available to us. And I think what's been exciting, you know, the order itself makes clear that the enforcement work of the Justice Department is independent. And so that's one thing that stayed very much the same. But I think, you know, one of the consequences of our independence has been that sometimes we overcorrect for the ways in which we can cooperate across government. And their antitrust enforcers, Congress really, you know, and Candace says that they spread the love all across the U.S. Code, and it's totally appropriate and really essential at a moment like this for us to dig in and to work together. I'd just say, you know, that the necessity, I think, is seen in part in our resources. Congress definitely packed the U.S. Code with antitrust authorities, including industry-specific antitrust authorities. But, you know, one of the things when I started the Justice Department in January of 2021, I was working for the Attorney General, and I handled the budget for him, which talk about an unglamorous set of responsibilities. Doing a budget for a federal department or agency is usually not very fun, but I will say it's part of what led me to the Antitrust Division, because one of the specific questions that the Attorney General had was, how does the size of the Antitrust Division compare to 1979, when I was first at the Justice Department? And the answer is, in 2022, which was a year where I think we saw a 70% increase in reported mergers, we had 358 fewer employees, fewer staff in the Antitrust Division than we did in 1979.
Wow.
And today, we have fewer employees, but still about 223 fewer employees.
Well, I'm really glad that you're all superstars then, because you clearly are doing the work of three people, each of you. I know we're coming up to the end of our panel. I know, go ahead,
Yeah, actually,
Andy.
can I just mention one thing
Yes.
on the, you mentioned a few areas. Section 8, I think people should, as Assistant Attorney General Cantor has indicated publicly, that's going to continue to be a priority for us. I know we've issued a few press releases over time, but we have many active investigations on that. The other area I would mention is potential 7A violations.
You might want to explain to the audience.
Yeah, sure. So this is if there are violations of the HSR Act, and we are concerned about compliance with the HSR filing obligations, and so we have some open investigations there. We're also trying to think creatively of ways in which we can make sure that companies are taking their HSR filing obligations seriously by putting more resources on investigating filings. So that is something that, you know, this audience should know, and, you know, you all should take back to your clients.
That's very interesting, Andy. And on the 7A side, is it failures to file that you're looking into? Is it, you know, for example, failure to produce all of the responsive item 4C, 4D?
It could be a variety of things. I mean, obviously, there could be noncompliance with because of item 4 or other types of documents that are required to be submitted, gun jumping type violations as well. So there, you know, I'll put that into a big bucket. But obviously, as you point out, one of the big things that we're focused on is making sure that we have the documents that are required to be submitted under the HSR Act. And if we don't, then it really substantially impacts our ability to do our jobs well. So we view this as sort of an existential problem if people are not complying with their obligations.
I think a related thing in terms of gun jumping, I saw in a speech from AAG Cantor that you're also focused on looking at due diligence and whether, particularly in strategic transactions, due diligence could be a means of facilitating anti-competitive conduct. That's an area of focus. Is that right?
Yes.
Sorry.
If he said it, yes.
I know we're coming up to the end of our program. I did want to give a chance for, maybe 1.5 questions. If anyone has a question, please stand.
Jeffrey Frost. A 1978 decision before the Supreme Court where the government was the petitioner was United States versus Gibson. And in Gibson, the Supreme Court enunciated a principle that information exchange could be pro-competitive. Gibson was a criminal case. And the court announced the principle that in order to convict of an information exchange, because it was in a gray zone, you needed both an intent to enter into the agreement, which is standard conspiracy, but an intent to achieve an anti-competitive effect. When the ABA antitrust section wrote its sample jury instructions in 1984, the committee anticipated a criminal information exchange case. When those were revised in 2009, Scott Hammond, Mr. Comar's predecessor, felt so strongly that there would never be an information exchange criminal case that he had those removed from the ABA model jury instruction. This question is directed to Mr. Kumar. Do you think there ever will be a possibility now of an information exchange that is criminal if there is an intent to achieve an anti-competitive effect, as Gibson required?
Hopefully everyone heard that. That was not a plant. Good question.
That's a great question. It's not something that I've been able to give much thought to, honestly, at this point. I think that's certainly something that would be, within the trend of what we were just talking about with Fiona in terms of thinking about ways to add greater versatility to the prosecutor's toolkit. Here I'm thinking specifically about the Section 2 cases that we have brought in the past year after talking about that about a year ago. I think I'll sort of leave it at that. That's definitely something for me to take back and think about. Thank you.
And could be the subject of an upcoming workshop. With that, I know we have many more questions we'd love to discuss with this panel, but they have other things to do, including a court case to go to. So please join me in thanking them.